fast.
So good afternoon, everyone. As mentioned by Attorney JJ, I am State Counsel Ange Medina of the Department of Justice, Office of Cybercrime, and I am here to share with you some points regarding cybercrime investigation and prosecution in the country. Okay. So it is our objective that after this presentation, the participants will be able to be familiar with the provisions of the Cybercrime Prevention Act of 2012, learn who the competent authorities responsible for the enforcement of the Cybercrime Prevention Act of 2012 are, learn about the Department of Justice Office of Cybercrime and its role in cybercrime investigation and prosecution, and of course, gain practical knowledge on how the government is handling cybercrime investigation during the pandemic. So with that objective, you can see the outline of this presentation. And as you can see, we would also be discussing about advisory opinion number 1, series of 2018 issued by the DOJ Office of Cybercrime. And this advisory opinion is entitled Institution of Cybercrime and Cyber-Related Cases. To give a foundation of this discussion, it's worthy to note about what is the policy of the state in our cybercrime law. So due to the advent of technology, it has become the policy of the state not only to protect and safeguard corporeal and tangible properties, but also to afford the same safeguards to intangible properties from all types of misuse and abuse. So in particular, the state has recognized the necessity to protect and safeguard the confidentiality, integrity, and availability of computer data and computer systems by adopting mechanisms to effectively prevent and combat offenses committed against them by facilitating their detection, investigation, and prosecution at both the domestic and international levels. So in this regard, the Congress passed the first comprehensive law on cybercrime in 2012, and that is the Cybercrime Prevention Act of 2012. So our law, as mentioned earlier at the first part of this webinar, is basically patterned after the Budapest Convention on Cybercrime, which is the first international treaty that seeks to deal with computer crimes and crimes committed over the internet. So our cybercrime law, consistent with the policy of the state to protect intangible properties and to facilitate the investigation of cybercrime, is divided into 3 types of provisions, and which relates also to the 3 aspects of cybercrime investigation and prosecution. So first would be the substantive provisions. Kanina medyo na-discuss na ni Justice yung mga substantive provisions. And these are the provisions that provide for the cybercrime offenses under the law and their respective penalties. So the second type of the provisions in our cybercrime law are the procedural provisions, which equip the law enforcement authorities with technical capacity in order to facilitate the conduct of cybercrime investigations. So the warrants, the preservation order and the warrants that were mentioned earlier by Justice, these are the procedural tools that are being used by our law enforcement authorities, the NBI and the PNP, to facilitate the investigation of cybercrime cases. So lastly, the third type of provisions within the Cybercrime Prevention Act would be the provisions on international cooperation, which seeks to address the transborder nature of cybercrime. When we say why do we need, or do we specifically why should we specifically include the international cooperation mechanisms in the cybercrime law? It is because we know that cybercrime is of transborder nature. So an illustrative example of this would be that a cyber criminal can launch an attack and perpetrate a crime against anyone situated anywhere across the globe, or in a case involving the or example is a case of proliferation of child pornographic material in social media. So paano yon? For example, someone who would commit illegal access, hindi necessarily na andito siya sa Philippines. So kahit na yung target niya, the owner of the account, for example, a Facebook account, is here in the Philippines, the perpetrator of the crime can be somewhere else across the globe. So in that regard, we can see the transborder nature of cybercrime. And also, for example, in the case of proliferation of child pornographic materials in social media. So the PNP or the NBI, for example, they have an intelligence, or there was a report that a certain John Doe was proliferating or distributing child pornographic materials through Facebook. So in this scenario, for us to learn who this John Doe is, or to have the subscriber information of this perpetrator, we need to coordinate with Facebook or get the computer data or the records pertaining to this John Doe account from Facebook. And Facebook is a foreign company, and Facebook is a foreign company situated in the US. So from there, you see the transborder nature na while we are investigating a crime here in the Philippines, there is an essential need for international cooperation, because maybe the perpetrator of the crime is nasa ibang bansa, o kaya the electronic evidence that you need in furthering the cybercrime investigation is at the hands of someone in another jurisdiction. So those are just illustrative examples, but syempre there are a lot of scenarios that can explain the transborder nature of cybercrime also. And thus, because of that, the need to foster effective and efficient international cooperation among neighboring states comes into play. All right. So, nadaanan na to kanina ni Justice, but let's just read them. Basically, the offenses under the substantive provisions of the cybercrime law, they are divided into three categories of cybercrime offenses: the offenses against the confidentiality, integrity, and availability of computer data. So these offenses, yung CIA offenses, these are the offenses related to cybersecurity, and the target of the offense would be negatively affects the confidentiality, integrity, and availability of computer data, or what we know as the CIA triad. Um, put simply, the private information should stay private. It should be confidential. It should not be changed without the permission of the owner, and the data, services, and systems should be accessible to the owner at all times. So that's on the integrity and availability part. It is also worthy to note that the substantive provisions of the cybercrime law uses technology neutral language, so that the substantive criminal law offenses may be applied to both current and future technologies. Kung babasahin nyo yung ating cybercrime law, makikita nyo doon, like for example, illegal access. It was written in a technology neutral way that that even if in the future there would be other technologies that would emerge na magiging iba yung way how the illegal access was committed, but papasok pa din siya as among one of the offenses in the cybercrime law. Okay, so we also have computer-related offenses, computer-related identity theft, computer-related fraud, computer-related forgery, and content-related offenses, cybersex, online child abuse, child pornography, and cyber libel. So this was also discussed earlier when the commission of traditional crimes or crimes punishable under the revised penal code at yung under special penal laws when it was committed through by or with the use of information and communications technology, the penalty is 1 degree higher. All right, so now let's go with discussion. I saw the list of our participants, and most of them are private practitioners, right, Attorney JJ? Most of
There's
them
a
are
mix oren. There are a lot of prosecutors.
oh,
We also have judges. Who
oh,
signed.
okay. So legal practitioners. All right.
Apa.
Um, it's worthy to note that we know sino ba yung law enforcement authority. If there is a cybercrime incident, kanino ba lalapit yung mga victims, or if you're a lawyer, kanino mo ilalapit yung kaso ng iyong kliyente. So under the cybercrime law, it is clear that the law enforcement authorities that are responsible for the efficient enforcement of the provisions of the cybercrime law are the NBI and the National Bureau of Investigation and the Philippine National Police. And they were also instructed to organize their cybercrime unit and manned by special investigators to exclusively handle cases involving violations of this act. So in this regard, the NBI created their cybercrime division, and also ang PNP, they created their anti-cybercrime group. So kung maririnig nyo from the news kapag nakakarinig tayo ng cybercrime operations, lagi ang nababanggit, the operation was led by the PNP Anti-Cybercrime Group and the NBI Cybercrime Division, because these are the special units that are tasked to handle cybercrime and cyber-related cases. But in relation to the discussion on who the law enforcement authorities are, let us discuss the advisory opinion number 1 series of 2018 that was promulgated by the Department of Justice Office of Cybercrime and signed by SOJ Guevara in 2018. So this advisory opinion was promulgated following different interpretations and numerous queries received by the Office of Cybercrime regarding whether or not it's a necessary requirement to first file a report, or for the PNP-ACG and the NBI-CCT to undertake an investigation of a cybercrime incident before the victim can file a case before the prosecution service. Kasi kung mapapansin nyo, the last sentence of Section 10 of RA 10175, nakalagay doon that the special units manned by the special investigators are to exclusively handle cases involving violations of this act. So there were interpretations that you cannot directly file a case before the National Prosecution Service or file the case before the prosecutor's office without going through an investigation sa PNP and NBI cybercrime units. So we heard also that there were cases that were dismissed or mga filing daw na hindi tinatanggap. So because of this, the Office of Cybercrime issued the advisory opinion which says that prior investigation or assistance of law enforcement authorities ng PNP and NBI in case buildup is not necessary in filing of complaints for cybercrime and cyber-related cases, such as when the identity and location of the perpetrator have already been identified and there is enough evidence to prove the presence of all the elements of the offense. So hindi necessary. Hindi kailangang dumaan muna sa NBI and PNP bago ka makapag-file sa prosecutor's office. However, if there is a need for you to use the procedural tools if there is for you to need the procedural tools that are available under the rule on cybercrime warrants, which are the same that are under the procedural tools of the Cybercrime Prevention Act, doon kailangan mong dumaan sa PNP at sa NBI because, as discussed earlier by Justice San Pedro, it is only these law enforcement authorities who can use or apply for these warrants or procedural tools. So kung nakikita mo na yung case mo medyo mahina pa, it's not yet airtight, you need to get more electronic evidence, you need to know who the perpetrator of the crime is, and by doing so, you need to ask electronic service provider to provide subscriber information to further the case that you are building. Dadaan ka sa PNP at sa NBI because sila lang yung they are the competent authorities to apply for these warrants. Okay. The next part of the advisory opinion is that it answers the question si ACG at si CCD lang ba? Sila lang ang merong right to they have the exclusive right to handle cybercrime and cyber-related cases. Na ibig sabihin, you can't file a cyber-related case to another unit of the PNP or the NBI. So the answer of the advisory opinion of the DOJ says that no, and that the phrase to exclusively handle cases involving violations of the cybercrime law does not confer the ACG and the CCD the sole authority and competence to investigate cases involving 10175. So mapapansin nyo sa news, like for example, it's a cyber-related case or it's an online child pornography case. So cybercrime, cyber-related case, but the law enforcement authority that has been investigating and doing operations in relation to this crime is not the ACG or not the CCD, but the Women and Children Protection Center of the PNP. O kaya if it's an online human trafficking case na ginamitan ng information and communications technology, ang naghahawak sa side ng NBI would be the Human Trafficking Division, Anti-Human Trafficking Division. So it's not necessarily na cyber-related case is that ang hahawak is the ACG and the CCT, because of course if there is another unit that's competent to handle such case, like for example online child pornography cases, then it is handled by a different unit of the PNP. So rather than the exclusivity pertains na ACG lang at CCD yung maghahawak, the exclusivity phrase provides a limitation on the types of cases that may be handled by the CCD and the PNP ACG. Okay, now let's go further on what is our office, the Department of Justice Office of Cybercrime, and what can we do, or what is our mandate, and how can we help you in cybercrime investigation and cybercrime prosecution. So the international cooperation mechanism of our cybercrime law is lodged within the Department of Justice Office of Cybercrime, which is designated as central authority under the cybercrime law for all matters relating to international mutual assistance and extradition as far as cybercrime and cyber-related case is concerned. So it is also competent authority for all requests for assistance for investigation or proceedings concerning cybercrime and cyber-related offenses. So I'll give you an illustrative example. So for example, Senior Agent Senora, who will be with us later, he's investigating cybercrime involving a phishing email. So, meron siyang email address, meron siyang Facebook account na ginamit din at some point in the phishing email. And kailangan niyang makuha yung information regarding those accounts. So it is the Department of Justice as central authority or is lodged with the international mutual assistance and international cooperation powers in cybercrime and cyber-related cases. Siya yung makikipag-coordinate, siya yung magiging bridge between the law enforcement authority, the PNP and the NBI here in the Philippines, and the competent authority doon sa ibang bansa in getting this necessary electronic evidence. So, na-mention din kanina ni Justice San Pedro, like for example, na meron tayong may na-issue na warrant, and this warrant is to be served to a foreign corporation, like for example, yung ating mga electronic communications service providers like Facebook, like Gmail, YouTube, and Instagram. Kailangan natin silang servan nung in-issue na warrant. This, under the rule on cybercrime warrant, should be coursed through the Department of Justice Office of Cybercrime. Also, we are also a competent authority for all requests for assistance for investigations and or proceedings concerning cybercrime and cyber-related case. And ang nangyayari lang, like for example, merong pupunta sa amin sa office and they would report an cybercrime incident, we would do initial investigation, but at the end of the day, if it really merits further investigation, we refer it to the NBI and the PNP, who are the law enforcement authorities under the cybercrime law. So it is the NBI and the PNP pa din who ang magkakandak nung cybercrime investigation. But the DOJ OOC would assist them, like for example, in getting electronic evidence from abroad or giving legal advice in relation to the cybercrime incident. Okay, so we are also the 24/7 point of contact in line with Article 35 of the Budapest Convention. So ang 24/7 point of contact, para siyang 24 by it is a mechanism under the Budapest Convention for the member countries to provide immediate assistance for the purpose of cybercrime investigations and proceedings. So we can provide provision of technical advice to our foreign counterparts. We can assist them for preservation of computer data. We can assist them with collection of evidence and giving provision of legal information and the location of suspects, and vice versa. Kapag kailangan natin ng tulong ng ibang bansa, the law enforcement authorities here in the Philippines will course through the request for immediate assistance through the DOJ and papunta sa ating foreign counterparts sa ibang bansa. Okay, so what would be the advice that kapag may lumalapit sa aming clients regarding cybercrime and cyber-related cases, what are the advice na nabibigay namin sa kanila? So basically, this would cover what type of offenses can be filed, saang law enforcement authority sila kailangang lumapit. Should it be with the ACG? Should it be with the CCD or what special unit? Or should it be with the NPC kung sakaling it's a data privacy violation? And also we can give them practical tips on how to reduce the financial impacts of cybercrime and what are the possible pieces of evidence needed in proving the existence of a cybercrime. Just a point of, it's not necessarily na involve lang ang Office of Cybercrime kapag ang pinag-uusapang crime is a cybercrime or cyber-related offense. As there are also instances that pwedeng yung request for evidence is coursed through the Department of Justice Office of Cybercrime kapag ang kailangan nating evidence or ang hinihingi natin from our foreign counterparts would be electronic evidence or electronic or digital evidence. So kahit na traditional crime yan ang ine-investigate ng law enforcement authorities, but we are dealing with the digital electronic evidence. The Office of Cybercrime can assist the law enforcement authority as to the proper handling or provision of technical advice on in relation to this electronic evidence. So this would be the last part of my presentation. What are the government responses in this time of COVID pandemic in relation to cybercrime investigation and prosecution? So first, we assure the public that there's continuing cybercrime operations even during the period of public health emergency in the Philippines. More of this can be shared by Senior Agent Senora. I know that he has good and successful cybercrime operations for the past months. And also there is an increasing of online presence. So the NBI, the PNP, and our office, we have increased our online presence by activating, for example, our social media accounts, where the public can ask questions regarding cybercrime and cyber-related cases. There is also strengthened interagency collaboration, fostering international cooperation, and we facilitate the members of the criminal justice system to be kept abreast of the global landscape and response to cyber threats, and of course raising public awareness. So that's my last slide. Thank you very much for your attention.